Good afternoon, fellow managers of this beautiful organization. We today will be discussing labor laws that are important for you to know. You'll be able to discuss with your employees as they come up to you and ask. General knowledge of these laws is important anyway, so you can recognize when injustices or violations do occur. We're going to go ahead and get right into the meat of the subject. We're going to dive right into the Civil Rights Act of 1964, the Employee Rights, Family Medical Leave Act, Safety and Health Standards, Affordable Care Act, Pay Equity, Fair Labor Standards Act, and the National Labor Relations Act. I, as the HR manager, if you have any questions, I am always here to help answer any. And then again, if you have any questions, I will email this PowerPoint to you all, and it will be available on Google Teams if you have any questions. So we're going to dive right into the specific acts and laws that you as a manager should know regarding labor law. Okay, and then we're going to go right into the Civil Rights Act of 1964, signed into law by President Lyndon Johnson on July 2nd, 1964, prohibiting discrimination in public places, provided for the integration of schools and other public facilities, and made employment discrimination illegal. So you as a manager, during the hiring and any employment process, an employee or future employee should not be assessed by their skills and an employee should only be assessed by their skills and education level and based on their qualifications needed to perform the job duties. Managers should not judge an employee or future employee by skin color, race, gender, color, and other religion. Managers should also be on the lookout for anyone who is doing this in the workplace so they can be given a lesson on civil rights and just basic human rights. So again, this is our first topic. Civil Rights Act was passed in 1964 and was to end segregation in all public places and explain that there's no tolerance for any kind of employee discrimination and future employee discrimination. People did not have to worry about being discriminated based on gender, race, color, or religion based on this act. Going on to the next one, we do have the employee rights specifically. Employee rights specifically refers to ADA laws, which are the American Disabilities Act, and that all employees have a right to not be discriminated against, no matter if they have a disability or not. Individuals with disabilities are protected from employment discrimination by Title I of the American Disabilities Act, again, ADA, and the Rehabilitation Act of 1973, per the U.S. Department of Labor. And so employee rights specifically has to do with the rights of someone who needs accommodations for your employer to do your assigned tasks based on specific disabilities that you have. Two laws that protect Americans with disabilities are Title I of the Americans with Disabilities Act and the Rehabilitation Act of 1973. Again, based on the U.S. Equal Employment Opportunity Commission, the Title I Act excludes any employer or labor union from discriminating against qualified individuals with disabilities in job application procedures, hiring, firing, advancement, compensation, job training, and other terms, conditions, and or privileges of employment. The Equal Employment Opportunity Commission describes a person with disability as someone who has a mental or physical disability impairment that hinders them from being able to perform everyday activities. So as the employer, the manager, you should be able to provide them with any assistance that they need. Like say if they needed a ramp or needed something built so that they're able to get to the job location, or you needed to work with them on their schedule because of the disability that they do have, you should be able to work with them. An employer is not allowed to fire someone if they need tools to complete a job and the employer has not provided or accommodated the tools for an employee to use properly. Again, reasonable accommodations should be made by the employer. If there is a test for the employee, they have every chance to pass, just as the next person. ADA laws also require employees to provide a qualified person to read to an employee, maybe because they're blind, or say an interpreter for an employee who is possibly deaf. The Rehabilitation Act of 1973 prohibits discrimination from federal assistance programs, federal employment, and based on a disability. So they have the options to use any federal programs. Basically, as a manager, don't count someone out because they have a disability. If they, again, have the qualifications to do the job, then they just need a reasonable accommodation. We're going to go straight on to the Family and Medical Leave Act. So we do have Family and Medical Leave Act provides certain employees with up to 12 weeks of unpaid job-protected leave per year. It also requires that their group health benefits be maintained during the leave. Again, it's to full-time employees who have been with the company for 12 months, and it's 12 weeks of unpaid leave. So during this time, the employee's job and position cannot be given away, and it is protected. Even though their pay is paused, their benefits are not. So this can apply to men and women alike, say like parents. According to the Department of Labor, the employees, if needed, need to be within 75 miles of the work site. This act applies to any employee. The reasons that would qualify an employee for the leave would be the birth of a new child, complications within pregnancy, adoption of foster care placement, to care for an immediate family member who is gravely ill, or if the employee personally cannot work because they have a serious impact to their health, or they're assisting a family member who is sick or maybe just came back from the military. And then, oh, I'm so sorry, I forgot to mention. So, as a manager, your expectation is before granting the leave, make sure that this employee does qualify. And then also, yeah, are they full time and how long have they been with the company? So then we're going to go on to safety and health standards. So health and safety laws are in place to make sure everyone is safe and that the hazards are not there and you're catching them before something does happen to your employee. OSHA also is an organization that is in place to protect any employees in case something does happen. So we don't ever want them to be requested to come on property because employee notices a lot of hazards. So you as the manager should notice hazards before they come up and then provide the proper protective equipment to any employee that asks. And then again, we should just host like yearly inspections just to make sure that everything is up to code, up to date, so that just in case the employees don't band together and require, say, an inspection of the vents and they do find mold because they've been coughing. We want to make sure that we get to that first before the employees, so that way we can show that, you know what, we care about your health. We are here for you. So just notice the inspector that you hire, they might even notice faulty or rotting construction that could have caused someone to fall and trip. By replacing the faulty construction, you are saving the organization from an employee injury and lawsuit. So that's what we want to avoid. We do have the Affordable Care Act that we're going on to next. This act's nickname is Obamacare because it was signed into law by President Obama in 2010. This law puts into place so that if a person, family can't afford a medical health care plan, there's now options for them based on tax credits. So it's based on poverty level. So if you're explaining healthcare plans, which you can't specifically choose the healthcare plan for the employees, but you can go over with them the healthcare plans that we do have, and you don't need to know the exact details, but as long as you can bring it up and explain to them what they mean, you can also explain that yes, if these healthcare plans don't work for you, we also have the Affordable Care Act that can be a great section option. And we're going to go into pay equity. So pay equity is the California Equal Pay Act is the main law under this category and was signed into law in 2015. So if you as a manager are brought up that there's a pay difference between two employees, you're going to go ahead and look at the role difference that maybe the male versus the female employee is doing and compare and contrast before siding with a party. Look at the employee's record and how long they've been there and what specific work they do, and also the similarity between the work that they do. So that way you can see, you know what, this is a noticeable difference and it is wrong. So I'm going to go ahead and address this, or maybe this is correct based on the roles that they're doing. So again, this happens sometimes based on the rules or the fact that maybe the women and men have the same education, but maybe the female versus the male decided to apply for a job that maybe doesn't require a college education at the same place of establishment as the male, but the male is getting paid more because he did apply for the job that requires the college degree. Also, the California Equal Pay Act changes every year. So, for example, effective January 1st, 2017, California law now prohibits an employer from paying its employees less than employees of the opposite sex or of another race or of another ethnicity for substantially similar work. So you want to make sure you're definitely noticing that. We're going to go on to the Fair Labor Standards Act, which establishes a minimum wage. Again, we're talking about pay. Establishes minimum wage, overtime pay, record keeping, and youth employment standards affecting employees in the private sector and the federal, state, and local governments. As a manager, your expectation is to make sure that the wages are being upheld, that we're not paying people less than what is to be paid, and that the amount of employees that are hired and the amount of hours that employees are working is is accurate. Anytime that the employee is doing any work for their organization, they should be paid, and also paid accordingly based on overtime work. So this act also as well protects child labor in the fact that minors have a maximum amount of hours they can work while also going to school to prevent the organizations from keeping them too long and too late. Go on to the next one. We have the National Labor Relations Act. So, this act grants employees two basic rights: the rights to form, join, or assist a union, and the right to engage in concerted activities for mutual aid or protection, which is any effort by two or more employees to improve pay, benefits, or working conditions. So, if you're there for your employees and you're listening to their concerns, again, maybe we can avoid the whole unionizing, and we can show them that we are listening. We do understand what your concerns are, and that maybe that we can show them that if you are unionizing, there is no retaliation. We are here. We want to make sure we can all come to a group consensus of what exactly it is that you would like from this organization. So again, under this act, the employees are allowed to collectively come together and bargain with the employer about what benefits or rights or wages they would like, and when they can all come to a uniform agreement, and again, you're not going to be retaliated against. And it's also called the Wagner Act by the main author, Senator Robert Wagner. All right, going on to just basically, all in all, what can you gather from this? What's next? What can you do as an employee, as a manager? So I recommend having weekly check-ins, meetings with your team. I challenge you as a manager to set up teams, so if you employees are under a manager, have a specific manager to go to for any questions they have. This will establish rapport within the organization, and the employees will feel more comfortable having someone to express their concerns to and not wait until things get really bad. Also, suggestion boxes are smart in that sometimes people like to anonymously say how they feel, and they might be shy and not like speaking up. So this gives them that opportunity. No matter what, whenever you see your employees, a smile definitely speaks 1,000 words. Go out there and make sure your labor posters are up around the office for easy viewing, preferably by the time clock. People always see that. And again, show you're approachable and available for any questions or concerns to your employees. Always brush up on labor laws in case an employee does come to you with questions. I will always have this PowerPoint, again, available 24/7 on YouTube via the link in my email to you all. And just if you have any questions, again, I'm here. And I do hope you enjoyed my quick presentation. I know we're running short on time, but thank you so much for joining me today. If you have any questions, again, you can email me. And again, I am Erica Ramirez Trujillo, your HR manager for the organization. Thank you so much for listening, and have a great rest of your day.